Hi guys, welcome to Commercial Law Tutorials, Law of Lease. We have already looked at the definition, requirements and the characteristics. Types of lease agreements we have, the duties of the landlord and those of the tenant. Today we are moving on to our last lesson, termination of lease agreement. In this lesson, we are going to discuss how a lease agreement is terminated. And at the end of the lesson, I'll give you popular exam questions relating to this lesson. A lease agreement is terminated due to the following: destruction of property, merger, expiry of time, effluxion of time, mutual agreement, notice to quit, use of forfeiture and insolvency clauses in the agreement, and also eviction. Let us first of all look at destruction of property. If property that is under lease is significantly or wholly destroyed by fire, earthquake, or any casualty, without tenant negligence, the tenant has the right to end the lease early, as the essential of the lease agreement, that is the subject matter of the lease, won't be available. The tenant is relieved from paying rent on the damaged property. So destruction of the property ends the lease. But note that in the case that the damage is caused by the tenant's gross negligence or intentional conduct, the tenant does not have the right to terminate the lease and will remain responsible for the damage he caused on the landlord's property. Next, we have the merger. Merger occurs when tenant acquires the landlord's freehold interest. When the tenant acquires part or buys the property under lease, the lease then merges into a freehold, hence terminating the lease agreement in this case. This is because when a merger occurs, the debtor and the creditor of a contract become the same person. The tenant has become the landlord also by purchasing the property under lease, resulting in termination of the contractual obligations. That is a merger. For instance, when the landlord A is leasing a flat to a tenant B, B then purchases the flat that is being leased from A, that is the landlord. B will then become both the landlord and the tenant in the lease agreement, therefore terminating the lease agreement. That is what we are saying. We have effluxion of time. This is the expiration of a lease term due to natural passing of time rather than from a specific action or event. So that is expiry of time. In this case, a lease ends on the expiry date. Expiration date refers to the date that the lease agreement is required to end according to the landlord and the tenant agreement. This is in reference to fixed term leases, for example, those that are for 1 year. So the tenant is required to vacate the landlord's premises on the expiration of that lease, and that is how the lease agreement is terminated. We also have mutual agreement. It is used when both parties agree to release each other from the lease agreement before the actual ending date. For instance, the landlord selling the property or tenant leaving for a new job or marriage. In this case, they agree to release each other from the lease agreement. So the contract or the lease agreement is terminated using mutual agreement. Both parties in this case negotiate to the point where they both protect their respective interests. They then agree to end lease on certain terms, after which they create and sign a mutual lease termination contract with the agreed terms of ending that lease. Next, we have notice to quit. It is a lease termination letter written by either the landlord or the tenant, informing the other party the intention to end the lease agreement with the date the tenants will end stated. It is used to end a lease agreement early also, for instance, where there is breach, or to confirm that an expiring lease term will not be renewed. One can give a notice to quit. We have surrender, that is next. It can be by deed or it can be implied by operation of law. During the surrender, the tenant voluntarily gives up his interest of being a tenant in the premises, and the landlord takes possession of the premises. For instance, the tenant removes possession from the leased property when he has hurriedly accepted a job in another country, vacates the property and returns the keys to the landlord. It is effective though if the landlord accepts, otherwise the lease continues. Forfeiture and insolvency clauses. The forfeiture and insolvency clauses are included usually in the lease agreement. They are discussed and outlined in the agreement that is made between the landlord and the tenant. These clauses gives the right to end the lease in the event that the tenant breach any agreed term in the lease agreement. For instance, failure to pay rent or renovate premises is agreed. This also applies to insolvency. The landlord can terminate the lease where tenant has become insolvent if they expressly said it in the agreement that if the tenant becomes insolvent, the lease agreement will end. So, these clauses can end a lease agreement also, as when these occur, the landlord just ends the lease agreement. Let us look at eviction. An eviction is an order from a judge removing tenant from the landlord premises, generally against tenant will, after tenant failed to comply, pay or vacate within the specified time frame given by the landlord. In this case, the tenant first of all is given the notice to quit by the landlord, but the tenant refuses to comply. This is when the landlord goes through the country courts to remove tenant. It is a legal process that is used usually for problematic tenants who refuse to perform as expected within the lease. That is eviction. Let us look at the questions we have. Explain how a contract of lease can be terminated. Explain how a contract of lease can be ended by mutual agreement, effluxion of time, notice, merger, and destruction. That was all I had for you. Thank you so much for watching. If you have enjoyed this lesson, don't forget to subscribe so that you won't miss the next video I will post.